Do you want time for rebuttal?
I do.
Thank
if
you.
I could reserve perhaps 5 minutes or
Fine.
so for rebuttal.
No problem.
That would be fine. Thank you. Members of the Commission, let me start by just making an observation if I can, and that is I've had the privilege over the course of time to represent maybe 10 or 12 different judges in judicial proceedings like this. And I will tell you that in all of those instances, I've been able to come to an agreement with the Judicial Tenure Commission on what is an appropriate resolution of the case. This is the one case that I've handled which has been different. And that's because from the very beginning, what has happened, I believe, is that we've looked at this case through opposite ends of the telescope. And the reality of this case, I believe, is that the facts are really not in dispute in terms of what occurred here. What is in dispute, and what I want to talk about, are really the conclusions of law that were reached by the special master. And I will confess that at least up to this point, I don't think I've done a very good job of trying to put in context what occurred on June the 24th of 2015. It was a 21, 22, 25-minute hearing that really is the sole basis, essentially, for this particular proceeding. And if nothing else, I hope that you put that into context. And when I talk about context, I am talking about the context of this litigation. For the judges on this panel, I think you would have to agree that this case was and is every judge's nightmare. 5 years of the most contentious, vexatious litigation imaginable. A case in which the plaintiff went through 16 different lawyers. Now I believe the plaintiff is on her 18th lawyer. The defendant has gone through 4 different attorneys. There were dozens and dozens of hearings in this matter, 13 separate motions for show cause orders. The register of action, essentially just listing the pleadings in this case, is 55 pages long. 55. And so if nothing else, I hope that you remember that context when you're thinking about and deciding this particular case. And without meaning to be offensive or condescending, I would suggest to you that you are put in a particularly difficult role and task. Because you're called upon to go back and reevaluate and reassess whether or not your initial decision to authorize the filing of this complaint is appropriate. That's not an easy task. The one thing I ask that you do, and trust that you will be able to do, is to keep an open mind as we talk about the facts and, more importantly, the conclusions that were reached in this particular case. So let's get to it. The special master, in essence, found 3 different types or areas of misconduct. The first, he concluded that Judge Gorcyca misapplied her contempt power by holding the Simone children in contempt for failing to participate in parenting time. That's the first. The second is that she had an inappropriate demeanor on the bench by making disparaging remarks to the Simone children during the course of the contempt hearing. And the third, she made a false statement in a response to the Commission's 28-day letter when she tried to explain the meaning of a hand gesture that she made on the bench. Now, the master's report contains almost 30 pages of factual findings that are the result of a 2-day hearing. And while we disagree with some of those findings, for the most part, for the purpose of today's argument, I'm going to accept those. I'm going to accept the factual findings, for the most part, of the special master. But what I do want to talk to you about and have a dialogue about is the conclusions of law that he reached based upon those fact findings. And the real problem, I think, that presents itself in this case, and I submit presents itself to you, is that the master's report, even if you accept all of the facts as true, there's no reasonable basis to conclude under the rules that Judge Gorcyca violated the rules of professional conduct, or in particular the rules of judicial conduct. And I want to go to specifically a rule that I think is particularly applicable, and I think you know, or you should be well familiar with it, and it is Rule 9.203B. which is entitled Review as an Appellate Court. And it says the following: the Commission may not function as an appellate court to review the decision of a court or to exercise superintending or administrative control of a court, but may examine decisions incident to a complaint of judicial misconduct, disability, or other circumstance that the Commission may undertake to investigate under the Constitution, and it provides a reference there. Here's what's most important. An erroneous decision by a judge made in good faith and with due diligence is not judicial misconduct. Despite that language, Commissioners, that is exactly what Judge Ryan found. Exactly what he found. Because with regard to this particular issue, what he found in essence was that Judge Gorcyca misapplied the rules when it comes to contempt. That perhaps she confused criminal contempt versus civil contempt. And that this fact alone results in judicial misconduct. And that's simply not what the rules say and not what the rules provide. And all you have to do in terms of reaching that particular conclusion is to look at the last paragraph in Judge Ryan's opinion, where he says the following: if the judge is going to use the inherent power of contempt, the ultimate tool in the toolbox, the judge may wish to consult the owner's manual to make sure that he or she are using the tool properly. Now, to be clear, we disagree that Judge Gorcyca improperly and misapplied her powers when it comes to civil contempt. But even if you agree with Judge Ryan's decision, you made a mistake. And the mistake is that this is a judicial error. This is not judicial misconduct. And how do we know that? Well, we know that by looking at the other fact findings that he made during the course of the hearing. And what did he find in terms of the facts? Well, in summary, he found that there was a lengthy history of parenting time violations, and at the time of the contempt hearings, the case had been pending for over 5 years, requiring 30 orders addressing the issue of parenting time and 13 hearings for alleged violation of those orders. He referenced the register of actions as being 55 pages long with the different lawyers who were involved in the proceeding. He acknowledged in his findings of fact that Judge Gorcyca had tried to craft many different solutions to the children's continuing and ongoing refusal to participate in parenting time, including but not limiting to having visits take place in the jury room, taking away electronics and television privileges, and requiring them to participate in family and individual therapy. He found that Judge Gorcyca gave the children ample warning about her ability to hold them in contempt, repeatedly explaining the consequences of failing to comply with the court's orders, even having them tour Children's Village. He found that Judge Gorcyca resisted contempt and used it only as a last resort, despite the fact that the prosecutor had suggested having a contempt hearing nearly a year earlier, and that the guardian ad litem, who had been appointed to represent the children as a whole, described their behavior as, quote, ridiculous and, quote, inexcusable for months. And it was even the guardian ad litem who recommended that because the children weren't getting the message, some type of draconian measure had to be imposed. Judge Gorcyca appointed attorneys for all 3 of the children before holding the contempt hearing and gave them an opportunity to personally address the court as well, which they did. None of these attorneys appealed Judge Gorcyca's opinion or decision, nor did the guardian ad litem. The master himself noted that the use of contempt is, quote, a very difficult substantive law matter area. You can find that in his report at page 10. But again, getting the substantive law wrong is not a violation of the rules of judicial conduct. And I respectfully submit that the judge's own report and recommendation establishes all of the facts needed to show that in this instance, Judge Gorcyca acted in good faith and with due diligence. The problem that I see here is that what the examiner is attempting to do, and to some extent, you see this evident in the master's opinion, is to apply what I call the magnitude of the alleged judicial error approach. And what do I mean by that? What I mean by that is that what they have focused on is the alleged magnitude of the judicial error. Well, this is horrific. This is a terrible situation. Children were sent off to Children's Village improperly. They were there for 17 days. They were led from the courtroom in handcuffs. This is a terrible situation, and that ruling has to equal judicial misconduct because it was erroneous. Well, that's exactly what the rules say is not the case. And think what that would mean if it were the case. Let's take that to its logical conclusion. If the magnitude of the alleged error is the measure of judicial misconduct, I'll tell you one thing, I wouldn't want to sit as a criminal law judge. How about the judge in a criminal law case who makes an error in terms of applying a Miranda analysis, or fails to properly research a search and seizure question, or fails to properly apply Michigan Rule of Evidence 404B in terms of similar act evidence, all of which results in individual cases, somebody being sentenced to prison, maybe for life, because the judge has made an erroneous decision. That's where this logically goes if we're going to apply that kind of standard here in this situation. Now, what's interesting is that there is absolutely no evidence that Judge Gorcyca did not act with due diligence and in good faith. Judge Wright doesn't specifically talk about that. He doesn't use those words, and respectfully I submit he should have. But if you look at the findings that I just indicated, which are there in his opinion, that's what it indicates, that she did act in good faith with due diligence. Now, interestingly enough, the examiner wants to turn that on its head. The examiner says specifically, quote, "There is no evidence in the record to support a finding of good faith, nor is there any evidence of due diligence." Well, first of all, I respectfully submit that's absolutely not true, based upon what I just indicated to you. And secondly, they're trying to shift the burden of proof. That's not our burden. That's their burden. All right, Mr. Defendant, prove your innocence. That's not how it works. There is no evidence of a lack of good faith or a lack of due diligence, period. And because of that, and because of the rule I indicated to you, 9.203B, if Judge Gorcyca, if she made a mistake with regard to her finding of contempt, that is not judicial misconduct, end of story, period. What's interesting, too, is if you take a look at page 19 of our underlying brief in footnote 2, you'll see that we have listed for you probably a dozen cases that have gone to the Michigan Court of Appeals within the past 10 years that deal with this very issue. The issue of whether or not a judge got it right when he or she held someone in contempt. To the best of my knowledge, in none of those cases, not one of those cases, was there a case of judicial misconduct alleged or filed or brought. And why not? Because it shouldn't be. Because that was a judicial error, plain and simple, that was corrected if it had to be, not always, but reviewable by the Michigan Court of Appeals. Let's talk about the second area, which is this claim of inappropriate demeanor. And let me start by making a personal observation based upon 4 years of practice. And what I'm going to be sharing with you, particularly for the judges on the commission, is certainly nothing surprising. You know, and I know, that there are judges that sit all across the state that are insulting and demeaning to lawyers. Whether it's yelling at a lawyer for being unprepared, being late to court, chastising a party for not taking a settlement when arguably the judge thinks it's in his or her best interest. That happens all the time. All the time. And I will tell you that some of the best judges that I've ever appeared in front of have been some of the most difficult. They don't hesitate to tell you how it is, and they don't suffer fools gladly. And I will tell you the language that I've been subject to at times is a heck of a lot worse than anything that occurred in a 21-minute hearing on June 24th in the courtroom of Judge Gorcyca. Now that obviously isn't the gold standard of judicial temperament, but it isn't sanctionable either. Unfortunately, what we don't do, and I hope the commission is going to do, is to rate people or rate judges on their who has the best personality. Although if we were to do that, I would submit to you that Judge Gorcyca would get exceedingly high marks. Again, we come back to this whole issue of context. This is a 21-minute hearing in a 5-year history of a case. There were dozens and dozens and dozens of other hearings. And I know that a number of you took a look at, and I'm glad you did, the hearings that form the basis of this particular case that occurred on the 24th. I suspect none of you, though, looked at all of the other hearings in which Judge Gorcyca provided in this most contentious case. And I respectfully submit that if there was a problem in any of those other hearings, dozens, dozens, and dozens of hearings, you would have heard about it from the examiner. But you didn't, because there isn't anything else. In fact, if you were to look at those other hearings, what you would find is that Judge Gorcyca was the model of patience. She bent over backwards to try to get the children to do the right thing. And the right thing was simply to have a relationship with their father. The children were caught in the middle. This is a horrific case of parental alienation. All Judge Gorcyca was trying to do was to balance the scales. That's exactly what occurred on the 24th as well. And if you look at that hearing in context, what you see is that she did not want to send these children to Children's Village. She was very encouraged by the fact that the mother indicated to them, the children, look, your father loves you. He wants to have a relationship with you. I want you to have a relationship with him. She even complimented the mother for saying that. That was probably the first time that that had ever occurred. She was explaining to the children and indicated to the children, look, don't make the wrong choice here. All I'm asking you to do is have parenting time with your father. Go have lunch with your father. Because the consequence behind door 2 is not a good one. You're going to be going off to Children's Village. And did she exaggerate, perhaps? Did she say things to make it seem and sound more difficult and onerous and unfriendly than perhaps it was? Yeah, I think so. But it was done with the motive of trying to get the children to just obey the order. There's nothing wrong with that. The other thing I think you have to keep in mind, and again I look back and cite to the rules, is Rule 9.205, which talks about standards of judicial conduct, where it says under 9.205B1, misconduct in office includes, but it's not limited to, A, persistent incompetence in the performance of judicial duties. B, persistent neglect in the timely performance of judicial duties. C, persistent failure to treat persons fairly and courteously. And I think that word persistent is there for a reason. And the reason is that we're not going to judge someone on a one-time occasion. If there's persistent mistreatment, persistent lack of civility, persistent lack of incompetence, that's one thing. This is a one-time occurrence. This is a standalone occurrence. And if we're going to judge judges by, I'll call it their worst day, you folks are going to be awfully busy. Awfully busy. That's not what the rules say, and that's not what's contemplated here by any stretch of the imagination. And they can't argue, and they haven't presented any evidence to the contrary. What they disingenuously argue is, well, she was repeatedly uncivil during the course of the 21-minute hearing. That's not what the rule contemplates. It simply is not. Now, lastly, let me talk just a little bit about the misrepresentation count. And I will tell you that, from my perspective, that is a tempest in a teapot, and it's much ado about very little. The misrepresentation count has to do with this hand gesture that Judge Gorcyca made during the course of the hearing. When she is addressing one of the children, and this notion that she's kind of swirling her finger or her hand by her temple. And the suggestion is that she was untruthful when she indicated that this wasn't supposed to signify that she thought that the child or the children were crazy. Here's what Judge Gorcyca said consistently, and consistently says today, from her answer to the request for investigation to the 28-day letter to her testimony in court. She said the following, look, my words now, but here's this accurate summary. You're asking me to go back and think about what I meant about something that occurred months earlier, 71 days or 81 days earlier. I don't know for sure what I meant by that. I believe, to use that word, I believed I meant talking about going forward with therapy. But I don't know that for sure. What I can tell you for sure is the following. I don't take the name of the Lord in vain, that I don't give people the finger, and that I don't use that symbol ever to indicate that someone is crazy. Now, looking at it objectively, can I understand, and do I understand how and why someone would believe that that's what I meant? Absolutely. I accept responsibility for that, and to the extent that anyone thought that, I apologize. But that is not what I meant, plain and simple. And if you do nothing else, if you have questions about this area, I would urge you to go back and look at Judge Gorcyca's testimony, which occurred on June the 1st. This year, 2016, when she talks about this very incident. It's compelling, and it is entirely rational and believable. What she says is, when I get the letter in and I see this allegation, first thing I say to myself is, no way, I didn't do that. Almost immediately, she sends her clerk or research attorney out to go pull the tape. Go pull the tape, let's take a look. I can't believe that this happened. Clerk does that. Comes back and says, Judge, I looked at it. Yeah, that's what it looks like. She says, no way. I did not intend for that to be the message with that gesture. That's all that's about. That's it.
Counselor, you have about 5 minutes left.
All right. Well, I'm going to stop right there. I think I've covered the things I wanted to cover, and I'm going to save my last 5 minutes. Thank you.
stay in the case.
Thank you.
Judge Talon, please stay on the
Oh, great question. Oh, I would be happy to tackle any questions.
Judge Talon, do you have any questions?
Not at this time.
Okay. Mr. Fisher?
None at this time.
Mr. Cortez?
No thanks.
Ms. Deal?
It's hard for me to believe that any judge would make disparaging comments about you, Mr. Kramer. Do you think comments made to an adult or to a lawyer are different than comments made to young children?
That's a good question, Commissioner Deal. I think they can be. And again, I would tell you, and I think Judge Gorcyca has in one form or another, that if she had to do it over again, she would have chosen different words. She would have been perhaps more respectful, more temperate, less frustrated. But again, I say to you that this is an isolated incident in the context of a very, very difficult situation. That I will tell you that I am 100% confident that if we look at the entire context of how she handled this case, it's exemplary. And I don't say that like it is exemplary in terms of what she tried to do, how she tried to handle an extremely difficult situation overall.
I am the senior member of this commission since Commissioner Ryan has recused himself,
Yes.
as young as I am. And I'm going to tell you, I've never seen such an outpouring of support for a judge in all my years on the commission. And it is clear to me that Judge Gorcyca generally does an outstanding job. That is clear to me. You said something about not to judge a judge on her worst day. But do you think conduct on one day can rise to the level of misconduct?
In theory, yes. In this case, no.
Thank you.
Commissioner Burmeister?
I do have a few questions, and looking back at the context of the case, you know, with parenting time orders, we start out with this presumption from the statute that it's in the best interest of the children to have parenting time with the non-custodial parent, right?
Yes.
So I don't think I'm doing a stretch here when I say the basic concept is when you enter these orders, it's for the best interest of the children, right?
I think so.
Okay. So I ask you those questions because when I listened to your argument about 13 show cause orders, and I think it's in your brief as well about a number of times of parenting time violation allegations, and then the comment that Judge Gorcyca addressed the children the way she did because it was a matter of last resort. And my question is, as I look at the record, it does not appear to me that either parent ever served any jail time on contempt. Is that true?
It's not really true. And let me try to be a little bit more specific. Sure. There were a number of instances where the father, through counsel, sought to have the mother held in contempt.
Right.
In, I think, 12 out of 13 of those instances, Your Honor, they were able to kind of work it out, if you will, because the goal was really to have this parent time be effective. There was one time in which the mother actually served, quote-unquote, a day.
This was the few hours in the holding room?
That's right. That's right.
And then the community service at the animal place?
That's right.
Okay.
Yep.
But that's it?
That's true, yes.
So my base question is, why is enforcement on an order or a set of orders that are issued for the benefit of children occurring on the backs of the children for whose benefit the orders are entered, when we don't have a parent here that has served apparently, I would take a little different view on whether that's serving jail time, but hasn't served any jail time on contempt. And that's my base question is, why are we in this direction instead of holding a parent who is a party litigant accountable for both violations and undermining the intent of the orders, including the orders that led up to the hearing that's at issue here.
Okay. Well, I think the answer to that, at least from my perspective, is that that was not Judge Gorcyca's goal. Her goal wasn't to hold anybody in contempt, in particular the children. She didn't want to hold the parents in contempt, in particular the mother. And I think that's evidenced by the fact that while there were these numerous show cause hearings, they found a way, through the lawyers and with the help of Judge Gorcyca, to work through it. Because the goal was not to find somebody in contempt. The goal was to get the children to comply. Just spend some time with their father. And I have to tell you, Judge, I don't really practice in this area per se, but the conduct of the children in this instance to me was nothing short of unbelievable. You go back to the situation in August, outside the courtroom when they were ordered to come to the court to hopefully have parenting time with their father. They're sitting outside Judge Gorcyca's courtroom in chairs, 3 in a row. They're locked arm in arm, staring down at the floor. And adult authority after adult authority comes out to talk to them to say, look, children, this isn't going to work. You can't just defy a court order here. We need you to come in and, I need some help here. We need to come in and simply have parenting time with your father as we're setting it up for you in the jury room. And the fact that they would do what they did, defy sheriff, a couple of deputies, assistant prosecutor. I mean, that to me is kind of beyond belief, but it helps to underscore just how far things had gotten out of control, how much the mother had done to alienate these children.
So if that's the case, though, isn't the mother the one that ought to answer for that alienation?
Well, I think so, but I think we're, at least from my perspective, we're kind of missing the point. I don't mean to be disrespectful to you in that sense.
Fine.
Sure. I mean, yeah, maybe she should have. Maybe she should have set the mother off for 30 days in terms of holding her in contempt. But again, that was not her goal. Her goal wasn't to punish. Her goal was to get compliance in something as simple as spending some time with your father.
Well, was there ever any evidentiary hearing during the course of this where the mother testified, I'm paraphrasing.
Sure.
Look, in so many words, I'm telling these kids to go have parenting time consistent with the judge's order, and they are just not listening to me.
No.
Okay.
No.
So, isn't one of the fundamental conflicts here whether it's the mother deliberately thwarting these orders or whether it's the children who are engaging in misconduct, so to speak, in terms of not doing parenting time? Well, I should back up. If there was such a determination that these kids simply just were not following their mother's directions, conceivably they could be considered incorrigible and have an action against them under the juvenile code, right?
Again, I don't practice a lot in this area, but I think you're correct.
Well, I ask you that because if that were the direction, the 9-year-old who was addressing contempt would be considered incompetent under the juvenile code, right?
I don't know.
Okay, fair enough. The 10-year-old might be considered competent, but would be subject to at least an argument for competency evaluation to see whether or not they could actually address the kind of claims being made against them, wouldn't they?
Perhaps.
Okay. When you make this argument about due diligence, and you tell me if I have it framed wrong, but it seems to me that implicit in that due diligence argument is that it contemplates a clear or adequate understanding of the law that you're dealing with relative to the folks that you're addressing orders to. Is that fair?
I think it's fair.
Okay.
But if I could add to that, Your Honor.
Sure.
I mean, there's certainly no indication, there's certainly been no finding that she didn't have that understanding. At worst, or at best, depending upon how you analyze it, she got it wrong.
Well, can we look at that for just a second? Let's
Sure.
just say, you know, because we're not dealing with a juvenile code action, we have a 9-year-old who apparently, at least as this proceeded, was assumed to be competent to address contempt and deal with the potential of being deprived of their liberty. And that's where we start, is that this 9-year-old can do that with the assistance of an attorney. The attorney there says, I'm not really clear what the narrative is on this, which is, at least as I interpret it, essentially saying, I'm not really clear on why this child is being accused of contempt or what they've done wrong. That's the first point. There's no stopping and clarifying what the claim of contempt is for this 9-year-old that can address contempt. And then the second part is that, and I'm going to shift gears here for a moment, but when we talk about the older child and this issue of civil versus criminal contempt, and I'm arguing that I assume you think it's civil, this whole concept of having the keys to your release, and there are things said like, well, whenever he stops acting like Charlie Manson called, come see me. Well, for a kid, how are they supposed to understand what that means in terms of the keys to their release?
All right, but aren't we still right back in the quandary that I had indicated before, Your Honor, and that is that what you're arguing, what you're suggesting, I think, by your questions, is that the contempt power was inappropriately applied in this instance. Again, if there was some indication that Judge Gorcyca was biased, that she actually knew, quote-unquote, the law and chose to ignore it, or somehow had some animus against the children, well, that's one thing. But all you're really saying, I would submit respectfully, is that she misapplied the contempt law. That's not a basis for finding judicial misconduct. Plain and simple. And again, what you can't run from is the fact that there was no finding, zero, by the special master of any lack of good faith or lack of due diligence. And as I recited those facts to you earlier, all you have to do is go back through his opinion. His opinion, in terms of the findings of fact that he makes, are just the opposite.
I didn't mean to cut you off. I thought
No, I said what I said.
All right. And we may be talking about both sides of the same coin, but your magnitude of error argument, I'm assuming you would agree with me, but if I have it wrong, tell me, sort of hinges on whether or not we make a finding that Judge Gorcyca was acting in good faith when she was engaged in these acts.
Yeah, I would agree with you.
Okay.
Yes.
And then, I think you said it fairly clearly, but just so that I am tracking with you, your argument on the 9.205B1 regarding persistent, the issue of persistence is, you would suggest the interpretation of that essentially deals with having separate hearings where you're persistently intemperate or something like that.
Yes.
Not within one long hearing where you continue to engage in intemperance.
Yes, that's exactly right. Yes.
All right. I think that answers all my questions. Thank you.
Thank you.
Commissioner Spickler?
I'm not sure this applies, but I have a curiosity.
Sure.
Do we have any idea of what effect the kids going to Children's Village has on them now, and where does this family stand now?
It's a good question. I'm not sure it is inappropriate, but I would confess to you I don't really know the answer to it. I can try to find out, but as I stand here right now, I don't know. Because eventually, as I think you know, Judge Gorcyca decided under the circumstances it's best that she recuse herself, and certainly I haven't followed the case from that point forward. It's been assigned to a different chapter. All right.
I don't have any questions. Any further?
I just wanted to ask a follow-up, because I think in response to Commissioner Deal's question, and something you addressed earlier, is that judges should not be judged on their worst day or their bad day.
Right.
And I believe you indicated that Judge Gorcyca indicated that upon reflection, she would have done things differently. But my recollection of the trial transcript is that when she was asked about that for her actions on June 23rd, or June 24th, that her response was that the only thing she would have done differently was not to have communicated to RT and NT, excuse me, that LT had elected to go to Children's Village. So the question, I guess two questions. One is that, did I miss something? And two, if not, she still look upon that as that she would not have done anything differently.
Judge Stalin, I think you're right. I think if you look closely at her testimony, it perhaps wasn't developed as carefully as it could have been or should have been. I take some responsibility for that. But certainly in every response that she's made to the commission, whether it's by way of a request for investigation, a 28-day letter, or certainly our briefings and what have you, we acknowledge that in isolation, looking back, that was not her best day. That she could have and perhaps should have chosen different words, taken a little bit different path, if you will. But I agree with you that perhaps on the cold record, it's limited. But if you expand that to other submissions that she's made, certainly I think that was and is her position.
Thank you.
Any other questions? Thank you very much.
All right, thank you.
Mr. Page, you may proceed.
Thank you. Good morning, everyone. I would agree with Brother Counsel. The facts in this case are really very little in dispute. They're shown in the evidence, the court documents that were admitted, and particularly in the video of June 24th. The master, after the hearing, found that respondent misused her contempt power, that she committed misconduct in her treatment of these children by using demeaning, humiliating language that went beyond acceptable stern language, and that the respondent was not truthful to the commission in her 28-day letter when she said the gesture she made during the contempt hearing for the 13-year-old, she didn't mean to imply that he was crazy, as she's comparing him to Charles Manson. We urge the commission to accept the master's findings of fact and conclusion of law. His report is very detailed. It is very well referenced and annotated to the testimony and the exhibits, the documents, the video. His findings and conclusions of law are very well supported by the evidence. So if the evidence shows that the facts are not really in dispute, what is in dispute is respondent now saying what her subjective intentions are, her spin on her actions, if you will, that I didn't commit misconduct back on June 24th. She argues that she does not insult people who come in front of her, and she didn't intend to insult these three children on June 24th. The video shows otherwise. She argues she did not mean to imply that the 13-year-old was crazy when she circled her temple with her finger and asking Dad to tell her when he's no longer like Charles Manson called. That she did not misuse her contempt power, even though for the first time in these objections to the master's report, she raises an argument that says, while I found the 13-year-old LT in contempt for violating a verbal order I gave him on June 24th in the jury room. She didn't say that in her answer to the formal complaint. She didn't say that in the 28-day letter. In fact, in the 28-day letter, she was asked specifically if she found someone in contempt for an unwritten order, and she said no. I found them in contempt for the order of June 23rd and for prior written orders. The June 23rd written order applied to the two younger children, not to 13-year-old LT. He didn't even have to be in court that day, but his mother brought it along. No, judges aren't robots. They're humans, they have emotions. but they can't let their conduct be ruled by emotions. The evidence shows in this case that the respondent allowed her anger and frustration to cause her to lose her objectivity and her impartiality and to act rashly and prudently. There's no doubt from the evidence of this case, the history of this divorce case was extremely contentious. It was very difficult. It was emotionally difficult on all parties, including the respondent. And there's no doubt that the respondent tried over and over again to help these three children have a relationship with their father. But while the history of the case gives reasons why the respondent's frustration caused her to act on June 24th, it cannot excuse her conduct on June 24th. The evidence shows that the respondent had thought about holding these kids in contempt before. They had been warned, I believe, by others in the hallway or in the jury room. She says on the record, I wanted to do this to you many times, but Dad said don't. The evidence showed that the respondent blamed the mother for the children's attitude to this parent alienation. And she repeatedly threatened the mother with contempt. But other than the one time when she put the mother in the court's lockup for a few hours in the morning and then gave her community service, she never did. She didn't hold the mother in contempt. So while she had thought about sending the kids to Children's Village before, she hadn't done it. But then suddenly on June 24th, she decided, I've got to have a contempt hearing now, and I'm going to do it. She acted rashly. She allowed her emotions to take control of her actions. She allowed her emotions to treat children in a manner that violated Canon 383, that a judge should be patient, dignified, and courteous, but also to demean these three children in a way that no one, let alone a judge, should do. Let's look at some of the evidence. Here's what she said to LT, 13 years old, wasn't even supposed to be there that day. And as counsel has pointed out, there's actually less than 21 minutes. There's actually two separate hearings, one for the older child, one for the other younger child. Both of them lasted less than 10 minutes. And in that time, this is what she said. Remember, LT started off saying, I didn't do anything wrong. I thought there were rules. She immediately questions his intelligence, saying, apparently you're supposed to have an IIQ, but I doubt that. She called him a defiant, contemptuous young man. You're defiant, told his mother. He's a defiant child. Told the 13-year-old, you have no manners. You young man have got it wrong. Your father is a great man. She said he should research Charles Manson and his cult. She said his behavior was unlike any she's seen in 46,000 cases, and said, you're the worst one. She told him he bought himself living in Children's Village and going to the bathroom in public. Called him messed up, clearly very messed up, very messed up. She told him, you're so mentally messed up right now, and it's not because of your father, implying that it's because of his mother. And when she did that, she uses her hands to gesture. She's pointing to her temple. You're mentally messed up. She describes his behavior as horrific. Speaking to the father, she told the father to decide when he changed and he was no longer like Charles Manson's cult while making circles around her temple. She told him he could be locked up until she was 18. In fact, she started off with for the summer, and then it just went, no, it's going to be until you're 18, showing she was being punitive and vindictive at the time. Then she said that his mother couldn't visit him in Children's Village. In fact, she said that his mother couldn't say anything more to him in court. When she tried to let me talk to him again, said no, wouldn't let the mother even say goodbye. The master had ample evidence in finding that respondent's comments were contrary to the Code of Judicial Conduct, clearly demeaning and insulting. This is what she said to the 10-year-old and the 9-year-old in less than a 10-minute hearing. The 9-year-old, you see the video, is visibly crying and sobbing. At one point, at the beginning, she's hugging her mother and burying her face in her mother's dress as she's crying, until the respondent tells the deputy tells the mother, "You've got to get away." She tells the 9-year-old, when she tried to read what her brother wrote, "Don't read what your brother wrote. You're not your big defiant brother who's in jail. Do you want to live in jail?" She told them, "Can you think of somebody besides yourself? What your father has gone through is unnecessary. It's despicable. I'm so upset with you. I'm more upset with your brother. And I won't say what I think about your mom." She referred to the mother reading the script that respondent wrote in the jury room when they tried to convince the children to talk to their father. "Well, your mom did something nice in the jury room for once. And I like your dad. Your dad is a good man." She told LT, "Your dad is a great man." Now, the judgment of divorce says one party can't disparage the other party in front of the kids. And these 3 children are in court, and the judge is praising the dad and disparaging the mother. She told the 9-year-old, "You're going to have your birthdays in Children's Village. Do you like going to the bathroom in front of people? Is your bed at home soft and comfortable?" Implying it's not going to be in Children's Village. She told them both, "If you don't have a nice lunch with your dad and make this up to him, I'm going to have the deputies take you to Children's Village." The 10-year-old RT refused to have lunch and said he wanted to go with his brother. To which respondent said, "Well, you won't be in the same cell as your brother. That's cool." In a mocking way, I'll put in there, "Stay away from your brother." When the 9-year-old NT refused, respondent laughed, said, "That's ridiculous." She told the 9 and 10-year-old, "I've never seen anything like this. You've been brainwashed. Everybody in the court thinks you've been brainwashed." She told the 10-year-old, "Wipe that smirk off your face. You're a defiant, contemptuous young man." She said, "Mom can't visit. No one on Mom's side can visit you in Children's Village." She said, "When you're ready to have lunch with your dad, have dinner with your dad to be normal human beings," implying that they weren't. She said they would be in Children's Village until Dad told her they were ready to be normal human beings, or they'd be there until they graduate high school. She's 9 years old. That's a 9-year sentence. A 10-year-old, that's an 8-year sentence. That's not even an appropriate sentence in a juvenile criminal case. And then she dismissed. He said, "Goodbye." The video shows respondent was demeaning, humiliating, intimidating, and disparaging to these children. It's not just what she said. It's not my inflections reading her words. Look at the video, and you can see her tone. See how angry she was to a 9 and a 10-year-old. How demeaning, sarcastic, and at times even mocking. If respondent thought that after 5 years of this difficult case that she could scare 3 children into now having a relationship with their father when she couldn't do it through 5 years of counseling and therapy, she just went way beyond reason. She told the 13-year-old, "I ordered you to have a healthy relationship with your father. When you can have a normal, healthy relationship, then I'm going to review this." She told the 9 and 10-year-old, "If you don't have a nice lunch with your dad and make this up to your dad, the deputies are going to take you to Children's Village." On these children is wrong. There's ample evidence in that hearing, in that video, in the transcript of that video, that shows the master's finding that respondent engaged in inappropriate demeanor in addressing these three children. She did not act in a patient, dignified, and judicial manner. She crossed the bounds. Respondent lost her objectivity. Clearly, she lost her impartiality because she blamed mom for everything. Praise dad. She took out her anger and frustration on the children. And the argument that she didn't abuse her contempt power, what she needed to do was take them all, not allow her emotions to control her. Give the attorney she appointed for the kid the more than 20 or 30 minutes they had to find out what's going on in this case, the history of this case. Stop for a second. Make sure that you are using the law of contempt properly. She didn't do that. The master found she misused her contempt power. Here's how. He found there was no order for the 13-year-old LT. The order on June 23rd applied to the two younger children and specifically said his parenting time with the father, the next parenting time, was July 14th, after the dad returned from out of the country. That's what the June 23rd written orders say. The only reason LT was even there is because mom brought him. She denied in her 28-day letter that she found contempt based on an unwritten order. She said the June 23rd and the prior orders. Now, for the first time, she says, no, I gave him a verbal order. Well, the record doesn't support the verbal order. What she did is, while the other children were supposed to have parenting time in the jury room, I believe it was the 10-year-old was in the jury room, she had the mom, she wrote out a script, had the mom come in and read it, and hoped that that would be a directive that the children would understand. Now they got to talk to dad. There was no verbal order. A verbal order, in order to be a basis for contempt, has to have the indicia, the finality, formality of a written order. There was no written order for LT that day. She got it wrong because this was not direct contempt. She told in both hearings, these children are finding in direct civil contempt. Direct contempt occurs in front of the court, in the courtroom. This did not. She was told not going well in the jury room. She was told prior not going well in the hallway by either her secretary or the guardian ad litem or a friend of the court counselor. It happened outside of the record. These children were not in front of her on the record until this day. It's not direct contempt. As the master found, this was indirect contempt. It occurred outside of the courtroom. It requires due process. It requires a show cause, affidavits. It requires some time for the attorneys who are appointed to represent these children to know what's going on. The master also found that the respondent misused her contempt power because if this is civil contempt, it is supposed to be remedial, not punitive. And the person found in contempt has what's called the keys to the jailhouse in their pocket. They can say, okay, I'm willing to obey the court now, and purge the contempt. The master found that the respondent gave the keys to the dad. And it's in the record. She said it over and over again. During LT's hearing, she said, when dad comes to me and tells me my son has seen the light, she said, so dad, let us know when that happens. To dad, if you ever think he has changed and the therapy has helped him, and he's no longer like Charles Manson Coe, you let us know. Okay, so LT could probably decide, yeah, I can talk to dad, but it's dad who gets to decide if it's enough and come to judge the respondent and say, okay, purge the contempt. During RT and NT's hearing, she said, I didn't send you to Children's Village before because of your dad. The ball is in your dad's court. Your dad is in charge unless you want to live in Children's Village. I will review this when Dad tells me you are ready. Otherwise, you're living in Children's Village until you graduate high school. She set a September 8th date as a review date and said, well, Dad, unless you come earlier and tell me. Respondent told Dad he would determine when they were ready to have a relationship. He will determine whether there would be an earlier review. She forbid Mom to have contact with the children. And she did this knowing that the following day, June 25th, Dad was going out of the country until July 14th. That was on the record on June 23rd. These children were sent to Children's Village for 17 days. Dad was out of the country. They could not furnish contempt themselves. The respondent argues that, well, the attorneys didn't object, but that does not excuse the judge getting it wrong. And while no attorney objected, the respondent said on the record June 24th, I'm doing this over Dad's objection and obviously over Mom's objection. She recognized the parents didn't want these children taken to Children's Village. But lack of an objection by the attorneys is not a defense. The same way that lack of an appeal or the fact that it is an appealable issue is not a defense. You know, the master knows the rules. The master knows 9.203B. And 9.203B says this body cannot act as an appellate review. That's true. Of course, that doesn't help respondent when misconduct includes such improper demeanor as this case or misrepresentation. They argue good faith and due diligence. Simply because it's an appealable issue doesn't mean that it cannot be misconduct. That argument has been raised and rejected by the Supreme Court as recently in Ray Morrow. A judge is required to know and follow the law. And it's not a defense to say, well, nobody appealed me. The Commission isn't here to review the conduct of the attorneys, but of the judge. And it ignores the impact that the judge getting it wrong has immediately upon these children. They're taken out of their homes, away from their mother, and put into Children's Village for 17 days. Mom can't visit, Dad's out of the country. Let's talk about the misrepresentation for a minute. The master found that respondents' answer in the 28-day letter was false. She argues, well, look, I said I believe, it's my subjective intent. Well, look at her testimony. First of all, she said during the hearing, I believe she didn't remember it, and as counsel argued, brought up the video, watched it. And then she told the Commission, in her answer to the 28-day letter, oh, I wasn't trying to imply that he was crazy. I was trying to say that he would make forward movement in his therapy. Well, the master said no, that's wrong. You know, the master determines credibility. The master makes the findings fail. There is evidence to show that it's wrong, and it's the best evidence. You can watch her do it. You can look at the video of June 24th, and you can see what she does and what she says. How do you know someone's intent? Look at their actions, what they say, how they say it. Watch the video. When she says to the dad, you tell me when he's no longer like Charlie Manson in his cult, it's pretty obvious what she meant. It's common sense what she meant. Counsel argues that this is an isolated incident. Well, one incident can be the basis of misconduct. And judges are supposed to be following the law, following the code of judicial conduct all the time. It's laudatory that she has a good record, that she has no prior discipline. It's very laudatory that she has all the support from the bench and the bar. But even good judges can commit misconduct. You know, and it's not the support for her that matters to this commission. It shouldn't be. It's not the media attention that matters to this commission. And it shouldn't be. You're an objective body. You're created by the Constitution. MCR 9.200 says to preserve the integrity of the judicial system, enhance public confidence in that system, protect the public, the courts, and the rights of the judges governed by these rules. Your function is to be objective and fair, to ensure the integrity and the impartiality of the judiciary. I don't believe that you can look at respondent's behavior, video of June 24th, and say, this is acceptable behavior by a judge. A judge can be allowed to treat children in this manner. A judge can use that angry tone, that language, talking to a 9-year-old, a 10-year-old, and a 13-year-old. That a judge can misuse her awesome power of contempt because she allowed her anger and her frustration, her emotions, to control her behavior. And she took 3 children away from their homes, from their mother, and locked them up. Her conduct requires a severe sanction, and the Commission should recommend to the Supreme Court a serious sanction. Thank you.
Thank you, Mr. Page. Commissioner Strickler, any questions?
Nothing right now.
Commissioner Brewmaster.
Thank you. I have a few questions. You just made a comment in your argument that Judge Gorcyca had good intentions throughout this case. In making that statement, would you concede that while you would take issue with the decisions she made and whether or not they were correct decisions, that relative to brother counsel's argument that she was acting in good faith?
No, and I don't think the master, he argued the master didn't find that she wasn't acting in good faith and in due diligence. I think the master found exactly that when he said that she misused her contempt power.
Well, I'm just trying to reconcile your statement and your argument. Are you suggesting she had good intentions all the way up until that day?
I'm saying she tried her best to foster this relationship between the kids and her dad. It was definitely frustrating. And that day, she acted rashly. She just acted impulsively.
Well, I suppose there's the question, does acting impulsively mean that you're not acting in good faith?
Well, I think they're sort of separate issues. I think certainly on June 24th, the good faith and due diligence refers to the judge following the law. Okay? 9.205B2 says conduct in violation of Code of Judicial Conduct is also a basis for misconduct. So, it's not good faith when you're using this kind of demeaning language and you're angrily yelling at 3 children in court. Okay? Good faith and due diligence would apply to, did she take the time to make sure she was doing contempt properly? And she didn't. It wasn't direct contempt. It didn't occur in front of her. She got it wrong.
And I understand your comment about why you think she's not engaged in good faith, but would you acknowledge that good faith is a fair defense for her if we were to find she was acting in good faith?
The court rule says good faith and due diligence as to legal decisions is a defense.
You also made a comment in your argument here that she had lost impartiality, that she was blaming mom for everything, based on one of the comments she made. I mean, if you look at this entire record, it at least as an outsider, would belie the idea that the mother was responsible for various violations and undermining court's objectives and its orders, doesn't it? I mean, doesn't it fairly reflect that she had culpability here?
Sure. So punish mom. Don't punish the kids.
Well, but the reason I say that to you is that when you say she made a statement that this is blaming the mother for these things, maybe the mother warranted some blame.
Yeah, and that's true, and she could make that conclusion. But it's different when you're telling the 3 children that mom is not the good person, that dad is the good person, and I won't tell you what I think of mom. She says this to a 9 and a 10-year-old.
All right. The other thing that I wanted to ask you about was you just said there should be a severe sanction in the brief, prior positions here. I think that there's been some advocacy for a 9-month suspension. Are you backing off of that particular figure in terms of the suspension?
We're not backing off that. That figure was, when we talk about this, we try to come up with a figure, and you look at precedent, if you can. You look at the actions in this case, look at what kind of precedent there is. About the only precedent that is similar is in Ray Post. That was in 2013, so it's recent. In that case, the judge locked up an attorney for asserting his client's rights for a few hours. Now, that was an adult, that was an attorney, and it was a few hours. In this case, you have 3 children, 9, 10, and 13 years old. Okay? She didn't lock them up for a few hours, she locked them up for 17 days. Okay? How do you compare the two of them? Well, this one's a lot more serious. The Post case didn't include any misrepresentations, as this case, that the master found in this case, nor the kind of demeanor that the master found in this case. This commission recommended, and the Supreme Court gave Judge Post 30 days. This seems a lot more serious.
Was part of any sanction supposed to be remedial? In other words, to help a judge understand that what behaviors are acceptable in one art, and to get them to, essentially have a deterrent effect, not do it again.
Certainly, to the judge and to the entire judiciary, and to the public.
So, let's just say, for the sake of argument, that a sanction was appropriate. Can't those goals be reached without something less than a 9-month removal from the bench?
That's up to the commission, and ultimately, the commission decides. Send it to the Supreme Court, to the Supreme Court.
All right, thank you.
Commissioner Deal?
Pass.
Commissioner Talon?
Yes. I think the facts of the different cases that have been talked about are significant, and starting with the issue is whether or not Judge Gorcyca violated the law of contempt, because the respondent doesn't concede that, but you argue that she did, and you talk about...
The master found that she did.
All right, but we can either accept or reject that.
That's correct.
All right. And the facts of Post, from what you tell us, because I have not read that, but my recollection is that it was a clear decision that holding the lawyer in contempt for asserting his client's Fifth Amendment rights was a violation of the contempt laws. That was pretty clear. You also talk about moral, and I believe what you're probably referring to in that case, and I know there was a variety of allegations there, is when, at least one of them, when Judge Morrow refused to remand a defendant after he had been convicted of a criminal sexual conduct case where a statute
That's correct.
mandated that the defendant be remanded. I assume in that particular instance, although I haven't read those transcripts, that the assistant prosecuting attorney that was present in the courtroom at the time told the judge there's a statute that says you have to remand the defendant, and the judge still refused to follow the statute. What we have here is a situation, and I recognize that Judge Ryan has said she violated the laws of contempt, and I don't know what to make the fact that Mr. Kramer didn't necessarily dispute that, or he didn't take issue with that. He took. I guess my point is, in some of the cases that probably both of you cited, is the in-rate contempt of Doherty, which I refer to as one of the Williams International cases. There was a citation in there, and there's tons of citations in everywhere, that the contempt process occupies what may be termed the twilight zone between civil and criminal cases. It really is a confusing area. And
The master recognized that.
Right.
The master knew the law of contempt.
right, so the question I'm getting to at this point is, if and that sort of goes to the argument about the magnitude of the fact that the children were sent to the Children's Village. I don't think I've read anywhere that said that had the parties agreed that she used the contempt law correctly, that would be prohibited. Did I miss something? Was sending them to Children's Village, had the parties agreed, was done properly? And let's say that wasn't really the issue. Maybe the issue was just the demeanor. Was that prohibited?
I'm not sure I understand your question, Your Honor.
Okay. If the parties agreed that she used the contempt laws correctly.
And by parties, you mean the parties in the divorce case?
No, let's say the issue here in this particular case had to do with demeanor.
Okay.
Okay, and maybe, and what the circular motion means.
Right.
If you agreed that the issue of the contempt was not in it, was the sending the kids to Children's Village prohibited?
I mean, is that something that she could have done had she done it properly?
Yes.
Yeah, she could have done it.
Okay.
Had she done it properly.
Okay.
And as I believe the Honorable Judge Burmeister pointed out, there are other tools, including creating juvenile cases, putting juvenile files on these children.
But then we're Monday morning quarterbacking.
Well, we are Monday morning quarterbacking, but the point is, you can't act rashly and not know what the law is, and that's what she did, and that's what the master found.
Well, what about, all right. So the respondent talks about the fact that the commission doesn't have jurisdiction on issues that where it's a question of whether or not the judge ruled appropriately, legally or procedurally was correct on the law.
Yeah. And again, I would refer to the latest case, which was in Ray Morrow. These arguments were raised and rejected by the Supreme Court, simply because it's an appealable issue, or simply because nobody objected. They also argued the slippery slope that, oh my God, you can't second guess judges like this. The Supreme Court said, yeah, it can still be misconduct. Yes, it's exactly what you can do.
Okay. All right. So I'll move on from that. Is there a distinction in terms of the gesture? Because if the judge had said, you are, and instead of using the word crazy or Manson-like, it simply made the gesture, would there be a distinction between then asking her what she meant by that when she is using other words and makes the gesture? And not as the gesture wasn't made to replace a word.
No, I mean, that's why you watch the video. In the context of this hearing in front of LT, when she says, you're mentally messed up, you're clearly messed up, and then she makes that symbol, that circular symbol, and say, Dad, tell us when he's no longer like Charlie Manson's called. I mean, it's clear what her meaning is. It's common sense. And the issue is that...
But what about whether, does it make a distinction? I mean, if she uses the symbol instead of using a word, it's much clearer that it's a conscious act. It's not as clear to me that it's a conscious act of making the symbol because she's using words. She's not using the symbol to replace a word, like giving someone the finger. Now, that doesn't mean I'm not troubled by her explanation of what it meant, but is there a distinction?
Well, there may be a distinction, but remember, the allegation is simply that she called LT crazy, and she said he was mentally messed up. The misrepresentation here is that she told the commission that I was not calling him crazy, that I was referring to forward movement he would make in therapy. And the answer said, no, you weren't. That's wrong. That's false.
Thank you.
Commissioner Fisher?
No, thank you.
Commissioner Cortez?
Assume that she misapplied the contempt law,
Yes.
what you're alleging she did with the master file. Judges in good faith often get it wrong and make mistakes. It's not infrequent. That's why we have a Court of Appeals and a Supreme Court. There's an ethical requirement for sure that judges maintain competency in the law. I know that's true. But why is this, in this particular case, this error sanctioned? Why is this one unethical and not all the other mistakes judges make? Is it because the impact on children, that the Court of Appeals can't give them those 17 days back? Or what is it in your mind that makes this unethical?
It's this in conjunction with her entire behavior that day, how she treated the children. Because it shows, again, she let her emotions rule her. Instead of taking a step back, instead of being sure that you're doing it the correct way, being sure the attorneys have sufficient time to talk to these children and find out about this case, get it's not occurring in front of you in court, and it's indirect contempt, do it according to the law. Get affidavits from the people who say they're not talking to Dad. Okay? Not just haul them suddenly into court. These three children who didn't understand, and clearly didn't understand what was going on, and start threatening them and demeaning them. And that, in conjunction with getting it wrong as far as the law goes, is what makes this misconduct.
So that you're saying it's not the misapplication of the contempt law in of itself, it's the context in which that misapplication happened?
That's correct. It's part and parcel.
When you look at the video, and we all watched it, she's clearly upset. At some points, my own opinion anyway, you can even say she might have been rambling. And to use a word, maybe snapped, which is understandable in light of the history of this case. I don't know that I would have lasted that long. But do you think it's possible, due to her frustration, maybe the heat of the moment, that when she was asked, whatever it was, 80 days later, the 28-day letter about that motion, that gesture, that she could have honestly, A, not even remember that she did it, and B, thought to herself, well, if I did it, I didn't mean to imply that he was insane, even though that is the universal sign for insanity. But do you think she could have honestly held the belief that, A, I don't remember doing it, and B, if I did do it, it's out of character for me, or it's not like me to do that and mean what they're saying?
I'm sure she honestly didn't remember it, but then she said she went and had the video pulled and she watched it. And then she said to the commission, oh, I didn't mean to say he was crazy. I meant something different. You know, when she testified at the hearing, well, she said, I didn't remember it. It's the fact that she thought, well, I've got to give you some kind of answer, so I'm going to give you one that isn't true, because I don't want you to think I was implying 13-year-olds crazy.
Okay, so let me ask you this last question. If in the 28-day letter reply, she would have sort of fallen on her sword and said, you know, I snapped. I've been dealing with these folks for this long. They got under my skin. I should have taken a break. I should have come back after lunch and cooled down or whatever, but I didn't. I should have. And when I made that motion, I was telling this kid, you're acting crazy. And I shouldn't have done it, but I did, and I'm sorry. Would we be here right now?
Probably not. You know, counsel said that every other case he's had, he's worked out. I mean, there was attempts to work this case out. Could not see eye to eye. You know, for whatever reason, there was a public hearing, and now there's this public hearing from the commission. And you're the ones who have to decide that is this behavior acceptable.
So, but it's not the gesture itself by itself, it's the alleged misrepresentation.
The misrepresentation is in the 28-day letter. Okay? The gesture was part of the entire hearing as far as how she was treating these children.
Okay, thank you.
Just to follow up on that, you're alleging she intentionally lied to the commission. Is that correct?
Yes.
Not that she honestly thought at the time she answered that question that was what she was thinking. It wasn't, when she answered that question, you're saying she knew full well that in fact she was not making, she knew full well she was making, and in fact, using the word Manson, using the gestures, that you're crazy. And so she intentionally did it, and it wasn't just something that she, well, you know, thinking back on it, I was hot, I was mad, and that's what I thought then, and now I guess when you look at it, it looks that way, and maybe I did.
Well, you know, she could have said
That's the real question I have here, because
Yeah.
I'm not sure. I mean, everything I've heard about Judge Gorcyca is that she's a very good judge. And this is a very contentious type thing. I have not been a trial judge. I've been an appellate judge. I've reviewed a lot of things. And I had to ask myself when I was watching this or looking at this, it was very moving to see it. And I query, would we be here if these were adults in front of her versus children? Would we? If she had done said the same things in the same concept to adults, is this a special category or that we have to deal with, or she should have dealt with in a more humane manner with children?
I think it's worse in this case because of the children and because of the age of the children. But a judge's demeanor is always something that can cause misconduct. The judge is supposed to be patient, dignified, and courteous. If she had used language like this to an adult, it's still, and in the tone that she used, the angry, the yelling.
Has the commission had any other complaints with reference to her tone or demeanor in the courtroom?
Not that I'm aware of.
Okay, thank you. Any other questions? Commissioner Fisher.
Being an Oakland County person, it is great to see all the support for the judge here. And I can't help but feel some concern that we're all here. I mean, the children, have had issues, the parents. I don't know how somebody can go through a case like this. So having said that, do you if these were adults, we probably wouldn't be. Is that right? Is that what you're saying?
I don't know that, because that language and her tone was still, beyond what a judge is supposed to do, beyond how a judge is supposed to treat anybody, let alone the kids. And as I said, it's laudatory. She has this fantastic record and this fantastic support from the bench and from the bar. Judges are supposed to have that. They're supposed to behave themselves all the time. You take a step back. If you've lost your impartiality, you say Mom was to blame for everything, you've lost your objectivity, then step back. Maybe take yourself out of the case if necessary, but certainly don't allow your emotions to overcome your actions and to act rashly. That's what she did on June 24th.
Had she responded differently, would we be here?
Responded to the commission differently?
Yes.
Certainly. I mean, we may not be here depending on that response. Her response has been, I didn't do anything wrong.
Thank you.
Thank you. Any other questions? Okay, thank you very much.
Thank you.
Rebuttal?
Yes. Chairman, thank you. Let me try and, if I can, just address a couple of the questions that were asked by the commissioners. I thought they were very thoughtful. Judge Allen, let me start with yours, if I could. I want to be clear that with regard to the issue of contempt, we do not agree that she misapplied her contempt powers in this case. But for the purpose of today's argument, as I think you understand where I was coming from, I'll take that up. I'll acknowledge that just for the sake of argument. But I want to be absolutely clear that we do not believe that she misapplied the contempt power. And in fact, one of the frustrating things that occurred in this case is that we were prepared to present expert testimony along those lines in the form of Judge Warren. And Judge Ryan basically said, I'm an expert myself. I don't need that. I'm not sure that was entirely appropriate, but that's what he decided. And so you don't have the benefit of Judge Warren's opinion, which I will tell you candidly is going to be that she did not misapply her contempt powers in this case. The other question you asked is that if it was applied correctly, could she have found and held the children in contempt? The clear answer to that is yes. They're children. Obviously, you have to use discretion, but there's nothing that says in the law that because they're children, she couldn't have found them in contempt. I think that's absolutely clear. Judge Burmeister, you asked I thought, a telling question that really gets back to this whole issue that I was trying to focus on. And here's what the examiner said. You picked up on it. Certainly, she had good intentions. She tried everything she could. You can't order someone to have a healthy relationship. I think that tells you all you need to know about good faith and due diligence in terms of the application and what she did in this case. The first two things I certainly agree with. You certainly had good intentions, tried everything she could. Can't order someone to have a healthy relationship. While that may be true in the abstract, I think what's more important is what you can't do is just throw up your hands and say, well, I give up. Okay, I guess the children aren't going to do what I say. I've tried for 5 years to get them to comply, and I guess they win. So, Dad, you're out of luck. Children aren't going to comply. They don't want to have a relationship with you. They won't spend any time with you, so have a nice day.
Yeah.
That's facetious, but that's absolutely the situation. It's one thing if this had occurred within the first 30 days of this case. This occurs after 5 years. She's tried everything, and it's not working. She didn't want to. If you look at that tape and you look at the evidence, she didn't want to hold him in contempt that day. The hope was, by ordering them into her jury room, and again, spending her time, that they're simply going to obey, have parenting time with their father. It doesn't happen.
Mr. Graham,
Please.
would you focus on the due diligence? Because I understand the good intentions and
Right.
good faith,
Yep.
but on that particular day, when those lawyers were assigned, and one of them had, less than 15 minutes, who said she wasn't prepared, the other lawyer didn't even know the child's last name. Would you tell me
Yes.
how, on that particular day, she exercised due diligence before finding those children in contempt?
Okay. Let's focus on what happened. She assigns the lawyers, one lawyer per child. And here's what hasn't apparently been fleshed out. Again, I apologize, I didn't do it. She doesn't set any time limits. She says to the lawyers, you tell me when you're ready. I'm here all day. When you're ready, tell me, we'll come back and we're going to have a hearing. So the suggestion somehow that they're confined to 20 or 30 minutes or whatever the case may be is certainly inaccurate. They had as much time as they needed.
Is that in the record?
I believe it is. I believe it is.
Because it did not seem that way.
Well, I will tell you, I will make that representation. I'll find it if you want me to.
And Judge Gorcyca never left the bench. It would appear that she's waiting for the lawyers to return. And the lawyer indicates, I don't
Right.
understand the full narrative. And the one little 9-year-old is sobbing uncontrollably when the lawyer comes in
Right.
because she's seen her brother put in handcuffs and taken away. So
Understood.
I'm worried about,
Sure.
help me with the due diligence on
Okay.
that.
Well, first of all, this is a motion day for her, so she's on the bench hearing other things, right? And I think if you go back and you look at the testimony of the lawyers who were appointed,
Mhm.
I believe all of them testified that they had a sufficient amount of time. Now, again, I see your skepticism, and I understand what you're saying. Should they have spent more time? Maybe they should have. But I want to be absolutely clear that she did not impose any time limits on the lawyers in terms of spending time with those individuals. None. And again, I'm not here to criticize or chastise the lawyers, but the fact that none of them took an appeal, the fact that the guardian ad litem didn't appeal Judge Gorcyca's decision. One of the lawyers says that when they come back in July, oh, well, yeah, I was thinking about it.
Well, didn't the guardian ad litem end up coming back to the judge to get her to undo the contempt order
Yes.
because Children's Village
Yes.
was in fact not an appropriate place?
Well, the guardian ad litem wanted the children back because, again, the idea was not to punish the children, get them to comply.
You want to wrap it up?
Yes, I do. And let me just make one quick comment, Chairman Sawyer, about this notion of lack of objectivity. She wasn't objective because she essentially found there were problems with the mother's behavior. I think as Judge Burmeister said, well, how could you? You had to find that. This was a case of extreme parental alienation. I think it was a credit to her that in the face of that, she didn't lose her objectivity. She tried as best she could to simply have the children have a relationship with both parents.
Thank you very much, counsel. Any further questions?
Sir.
That's fine. Mr. Page, you've offered an affidavit of Camilla Thompson, Administrative Assistant to the Commission, in support of your request for costs pursuant to MCR 9.205B. Do either of you have any objection to the entering of that?
No.
Being no objection, it is entered into the record. There being no further, nothing further, this commission will take this under advisement. On behalf of the commission, I want to thank both of you for very good arguments, very good briefs, very contentious case. It's a difficult case, and let me assure both of you that we will take these oral arguments very seriously. We will take this matter under advisement. We will issue an opinion, a recommendation, I should say, which turns into an opinion to the Supreme Court, one way or the other, based on our deliberations. Again, thank you very much for your help in this case, and the hearing is now adjourned.
Thank you.
All right. Proceeding has adjourned.